Franklin County Commissioners meeting, May 1st, 2018.
Good morning. Welcome to the regular weekly meeting of the Franklin County Board of Commissioners. Today is Tuesday, May 1st. All three commissioners are here together with County Administrator Keith Johnson. At this time, we'll call the meeting to order and ask you to join me for the pledge if you choose to.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
Okay, first item on the agenda this morning is approval of minutes. Are there any comments or corrections to the minutes as presented? If not, they can stand approved and we can move on. Not hearing any comments or questions.
Move for approval. Second. I don't know if we need to do that or not.
Yeah, my research indicates that it's not a requirement, and about 3 meetings back I recommended that we add them as an agenda item, and unless there were comments, changes, or corrections, they would stand as presented. But since we have a motion and a second, I think we're obligated to respect that. So all in favor, please say aye. Aye. Okay, so the minutes are approved. Next item on the agenda is zone change 2018-01 to amend the Franklin County Code section 1766-180, and understand that the Planning Department is here to talk to us about this.
Good morning.
Good morning.
Good morning, Commissioners. Thank you for this opportunity. Yes, this is a file, ZC 2018-01, which is technically a text amendment to the zoning code. And what the application was for was to allow roof pitches of 1/12 or less and for shed-style roofs. And the background on this is that an applicant came in and wanted to build sort of a modern design house, and he was told that that was not allowed. He was building within the urban growth area, and in that area we have certain design standards that disallowed it. Upon further research, we found that our code was supposed to mirror Pasco's code for those UGA areas, and they had since updated their code, and we weren't aware of it. So we took this to the Planning Commission, did all of the required public notices, took testimony. There was no opposition to this request, and so the staff had recommended approval of this change, and then at their meeting, the Planning Commission also recommended unanimous approval for this change.
So, quick question before we go to the board. You said that there's a requirement that our code in the UGA match the city's. I could certainly see that the city's code would be dominant in the city limits. When you get into the UGA outside of city limits, you're now in the county. So is ours supposed to match theirs, or is theirs supposed to match ours? Not that it really matters in this case, but I'm curious about the propriety.
Yeah, and it's not a requirement to match up, but it's an intent to sort of mirror those regulations.
Certainly makes sense.
Yeah, the idea is that those areas which are going to be eventually brought into the city would align with their chosen design standards.
Right, and that's something that we frankly don't do with our streets as much as we should. That's an issue for another day, but it's the same idea to make it compatible for when those areas are annexed. Okay, I've got a few other questions, but I'll defer to the other commissioners first.
No, so I understand it's the modern home, which you see some of them up there going up to where you walk up the hill, say out here, flat roofs. That type of modern home is what it is. It's just a more style change on the homes.
Correct.
Who would want a flat roof? Indians knew better than that.
Style.
Any other comments or questions?
That's all.
Okay, a few years ago I had a constituent come to me and they wanted to get a roof that had a different pitch, and we ended up getting a special use or an exemption or something for them. I went through the same process with my own property. When I built a support building, I wanted the pitch to be historically accurate, and the city was good about granting approval to do that. And in the process of that, I did a little bit of research. I don't know if this is accurate, but there were staff people at the city who told me that that original pitch restriction was based on a desire to limit the number, and this is at the time that manufactured homes were coming into popularity, to minimize the number of those, because the manufactured homes, if they built them with a flat enough pitch, they would clear the freeway overpasses. And so by limiting or restricting that pitch requirement, they thought they could minimize the number of manufactured homes, which is unfortunate because necessity being the mother of invention, they just put them down like this and assembled them when they got to the job site, which I think is kind of humorous. But I just thought that was an interesting backdrop to the whole discussion. What is a shed roof?
A shed roof is different than a gabled roof
Is it just a one-sided slope?
or a hipped roof, because yes, just one side.
Okay.
So again, that real modern look.
Okay. And I thought so. I just wanted to ask the experts. Okay. And we are adding an except and then a sentence at the end of our code. Does that grammatically mirror the cities? Is that what we're doing?
It does.
Okay. Because I thought there was probably a cleaner, simpler way to say it. But if it mirrors theirs, it reduces questions.
So we've done it, yes.
Okay. Well, I think it's great. And the last thing is that when that issue first came up a couple of years ago, I talked to the planning folks here at the Times before you were here and said, this is something we ought to fix. And shame on me for not following up to see that it actually got fixed, but I appreciate the fact that you're fixing it now. Okay. Any other comments or questions?
No, I just think it's probably a good idea to keep up style of house so we can, that has become more popular out there.
Okay. Well, we've got a package requires a motion for approval.
Mr. Chairman, I would move that we have a zone change 2018-01 to amend the Franklin County Code Section 1766.80 to allow roof pitches of 1/12 or less in 4 shed-style roofs.
Second.
Okay, we have a motion and a second for approval as presented. Other comments or questions? Cole, I just thought of one. Would this allow, because it mentions lower pitches on shed-style roofs, but let's say a prairie-style construction with a very flat pitch roof with long overhanging eaves, Frank Lloyd Wright style. This would allow that as well. It's not just a single-sided shed roof. It can be a low pitch.
Yes, as long as it's 1/12 or less. So the
So
code
what-
already allows it to be 5/12 or greater.
Right.
And in fact, that's the requirement. Anything that's in between though, 2/12 to 4/12 would not be allowed.
Okay. Well,
And that's just in the urban growth area and the rural shoreline areas of Franklin County. That's the only place where these restrictions apply.
So, given our climate with limited snow loads, modern engineered trusses, various roofing materials that can be used, steel, shingle, etc., is there any reason you can think of why a 3/12 pitch would be unsafe? Or, I mean, I can set aside the aesthetics of how it looks or doesn't look. What I'm looking for, is there a reason that I'm missing why we wouldn't allow that?
No, I think you identified the reason is because they were trying to exclude manufactured homes.
So I understand that doing this today probably makes sense to get us consistent with the city, but unless there's objection from the majority of the board, I'd like for you to come back with a proposal, at least for the county, to remove those kinds of pitch constructions, because there are roof pitch limitations. There are all kinds of designs and structures that look just fine, and especially a low pitch building with a lot of overhanging eave is energy efficient in terms of shade over windows, and I think they're even fairly attractive, but that's an aesthetic thing. Would that be something difficult for us to do? Could we do another code amendment just for the county?
We could certainly do that. It would not then be consistent with what the city has. How that would be the,
And I'm talking about the unincorporated county or outside the UGA.
that's already allowed. Any roof pitch is allowed in the other areas. This is
Okay. This is only within the UGA.
only within the UGA and the rural shoreline areas
Okay.
of the county
All
that
right.
this applies to.
Well, then
Otherwise, we don't look at
I'll
those.
direct my thoughts to the city then and see if we
Okay.
can persuade them to open things up the way the county does.
Okay.
Okay, great, thanks. All right, motion and second. Any other comments or questions? All in favor, please say aye.
Aye.
Aye. Okay, thank you very much.
Thank you.
Appreciate the education. Okay, we've reached time for our first of two public comment sessions or periods this morning. Anybody wishing to speak with or to the board on any county-related subject, this would be your first of two opportunities today. Okay, not seeing anybody wanting to do that, we'll move on to office business. Do we have payrolls and warrants to approve?
We have two sets of warrants this morning in front of us, Commissioner. The first being fund expenditures. There's like 14 miscellaneous items. Current expense, treasurer O&M, boating safety, solid waste, etc. The bottom line of these items is $599,776.38. Keith has looked at them, and Mr. Beaton and Macy have signed off.
Okay, I will second this motion.
Okay, we have a motion and second for approval of the fund expenditures as presented. All in favor, please say aye. Aye. Those are approved.
Second and final, I would move for approval of salary clearing payroll and emergency management payroll. The sum total of those two items is $980,995.99. Kinds of nines in there.
Okay, I will second this motion also.
Okay, we have a motion and second for approval of the payroll documents as presented. Hearing no comments or questions, all in favor, please say aye.
Aye.
Those are approved as well. Okay, next item under office business is the consent agenda, unless we have other payroll.
No, that was final.
That's it? Okay.
I would move for approval of the consent agenda 1 through 8 as presented.
With discussion, I would second.
Okay, there's a motion and second for approval of consent with discussion. Commissioner Miller.
Just we have Kyle here. I think maybe we should discuss this number. Where is it? 5. Let me look here.
I think it's 3.
Yep, 3. Yep, 3. Limited liability. So yeah, please.
Morning, Kyle.
Good morning. Okay, so you want to explain this one here? This looks like a limited liability company that we're going to
Sure.
have a new LLC or something.
Yeah, in Greater Columbia Behavioral Health Organization will, at the end of 18, December 31st, 2018, will cease to exist. And so their plan as of right now is to move forward to become an ASO, Administrative Service Organization, and manage the contracts for the state contracts for crisis services and for the federal block grant.
Okay.
And so,
excuse me, that is not a change. It's always been in the 2020 plan that the ASO would be the crisis and block grant only, right?
that's always been in the plan. It was undecided who would be the ASO.
Right, I understand.
Yeah.
But the ASO, MCO, split hasn't changed.
Correct, correct. And so with the Board of Directors, with GCBH's Board of Directors' decision to move forward with mid-adoption, that created the need to, if they're going to become the ASO, they can't form that January 1st of 19. There are things that they would need to do to prepare to become the ASO, and so that's the purpose of the certificate of formation, is to become the ASO, and then they would essentially have the ASO and the BHO operating simultaneously while they move towards preparing for mid-adoption.
This is a short-term LLC.
Yes.
What is the anticipated life of the LLC, and why would it end?
Well, and I actually thought that Jen was going to be here from the PA's office.
From what I read, I got the impression that the LLC was in perpetuity. And
Criminal activity.
And are they an ex officio board member for not voting, in which case they're not? Yeah. My first question is, why would you create an LLC? Okay, it is 9:29. For the purposes of documentation and the record, I'll just point out that at about 9:15, the recording system appeared to crash, and our IT folks not only got over here from another building, but fixed it and left in 14 minutes. That's pretty impressive. Appreciate that. So we'll close out our recess now. It's 9:29 by the clock. We're back on the record. And we were having a discussion with Kyle Sullivan about item 3 in the consent agenda, which is a Greater Columbia Behavioral Health Certificate of Formation to form a limited liability company that would exist, according to the documents, in perpetuity. Kyle, you and I had the benefit of a little side discussion during the recess. If I could, I'd just like to summarize that. Correct me if I get anything wrong, but it sounds like this limited liability company is being set up to provide the services that an ASO would provide under the state's new scheme for blending physical health and mental health care. Currently, Greater Columbia is not a limited liability company. It's a board with representatives from 8 or 10 different counties. And the question I was having that maybe PA's representative can answer, if Mr. Bell were here, I would ask him, but it seems that it sets up a scenario where we have a limited liability company established in perpetuity that would receive state money and potentially federal block grant monies funneled through the state to provide crisis services for mental health programs in our county and numerous others, and that we would presumably have county commissioners from those counties, including ours, serving on the board of this LLC, executing contracts to get this work done. And what I'm trying to sort out is the potential liability issues for the county if this is an independent body, an LLC, and a county commissioner from here is sitting on that board. Where do their loyalties and obligations lie? What is the liability for the county? How does joint and several play in? Those kinds of legal questions. I'm not accustomed to us having county commissioners serving on private legal entities, whether they're LLCs or C Corps or anything else, and being there in their official capacity as a county commissioner simultaneously. Jen, is that something you'd even want to try to tackle without any notice?
Yeah, I would not try to tackle that.
Do you think that that's something that warrants some investigation, or do you think that this is something we might just go ahead and approve today?
If you feel uncomfortable with approving it today, I'd wait. I think Mr. Bell's probably done the most research into it.
Right.
I'll be in the best position to answer it.
Right. Well, it certainly, think would have helped if he had been here today, but, and I'm sure that the intent of this package is certainly good, not questioning that, but I've got enough questions about the relationships and the liabilities for the county and, you know, how the LLC plays into it that I'm not comfortable voting for it today. If the other two commissioners want to proceed, then we can certainly do that. I'll just vote no.
And Commissioner Cook, correct me if I'm wrong. I don't know that I've heard their talk about once the end of this year and the BHO closes down. I haven't heard of the ASO being governed by a board of directors, and maybe I'm wrong. I know there has been talk about a leadership council, and you know, unfortunately, I don't have a definition of what that is, but it would. I think the makeup would be similar to the board of directors, but I don't know what that relationship would be, other than it's not called a board of directors, so I would assume it would be different.
Yeah.
I'm also a little vague on the notion of, you know, the ASO. If the status changes after 1 January, I don't know that we can rely on the historical practice of members of GCBH supporting individual county preferences for their county. You go to a leadership council, you've got limited money, you've got limited block grant funds. Now you're talking about where do those funds go, and do we get into a situation where we have competition between counties for limited funds that aren't earmarked for a particular county, like a block grant. I think I see a number of pitfalls that make me nervous. I'd want to have a conversation with Mr. Bell, I think. Ideally, I'd prefer to see an advisory board that is specific to Franklin County or Benton and Franklin that served as the ASO, recommending, and we'd be executing, this board would be executing contracts for Franklin County. But it may just be that I don't have enough knowledge about the proposed LLC, which I'm quite sure is the case, because I don't think I do.
So we have about, 9 counties involved in this. They all got to sign this certificate. It goes back to the BHO, and they, BOH, and they will make the decision based on those 9. If 1 or 2 drop out, what happens to the parent decision? I'm talking to Quentin Bob because he's on that committee.
Yeah, and I'm not sure. I know that there was one county that opted out. I think it was it Klickitat or Klickitat opted out, and they chose to go with southwest.
Southwest.
But I don't know. Jim Sizemore was at our last meeting, so I don't know where that transformation is yet either. So.
Yeah, and there's a statement in the package at 7.1 that talks about limitation of members' liability, and it's part of the LLC documentation, and presumably it's intended as some sort of indemnification if you're, say, a county commissioner serving on the LLC board, that you're not personally liable. The issue is the one that we talk about all the time, which is joint and several liability. Somebody brings suit. It really doesn't matter what your LLC formation documents say. The county's still going to get sued, and we can still be on the hook. So I understand the intent, but for anybody who sees paragraph 7.1 and thinks that protects the county, I don't think so. So anyway, we've had so much discussion here, I frankly don't recall if we had a motion for approval or consideration. We had a motion for approval of the consent that included this item. Unless there is a majority desire to approve item 3, it'd be appropriate for someone to motion an amendment to the motion that's on the table, and that would be to exclude item 3.
I made the motion, so I would, at this point, exclude number 3 until we have a chance to visit with Jim Bell.
Okay, and does the second concur?
Yeah.
Okay, so we have a motion and a second for approval of the consent agenda as presented. We also have an amendment to that motion excluding item 3. The second has concurred, so now we have a new motion, which is consent agenda for approval of all items excepting item 3. Any other discussion before we vote? Okay, all in favor, please say aye.
Aye.
Aye. Okay, so the consent agenda is approved, items 1, 2, and then 4 through 8. Item 3 is held over for future consideration. Kyle, thanks for your help. Sorry to hit you with 100 questions kind of out of the blue, but I think we'll all benefit from understanding that one better.
Okay.
All right, thanks.
Thanks.
Okay. Despite the break in there, it's still only 9:37, so I think we'll go ahead and sign these consent items quickly. And give Keith an opportunity to get ready. That when you're done, please. So Keith, do you know offhand what the difference between these two is? Because I meant to ask. I thought it was a duplicate entry. But the contractor is the same person, the services are the same person, the time frame is the same time frame. So we've got the same parties, the same service, the same time frame. Two different contracts, two different dollar amounts.
I'm not sure exactly why we have the resolution number is sequential 128.
I know.
There's 2 contracts.
Yeah.
Oh, this is functional family therapy, this is family counseling, and the distinction between the nature of that work.
Okay. Well, this is part of this. I only know that because my son is one of the people who does this. But if you think they're separate, we can go ahead and approve them. We've already approved them. We'll go ahead and sign them. If we don't need it, we can deal with the other one. Okay. I didn't look very closely at this one. I just assumed that it was administrative. Got at it twice. I didn't notice the 2 different resolutions. Yeah. Okay.
Those ready to be signed? I think he's done this one.
Yeah, I'm done. Thanks. We had 2 contracts, same contractor, same period of time, 2 different dollar amounts. The nature of the services were very similar, but there is this small language difference. It looks like it's 2 different kinds of service. Board like to proceed with the admin office business? Or do we want to wait till there's a signed?
Go ahead, as far as I'm concerned.
Mr. Miller, you ready to go?
I'm ready.
Okay, Keith?
Yes, thank you, members of the board. You'll recall on the 17th of April, we had a discussion with the Superior Court judges and regarding a request for funding for an attorney to represent them in an action with our county clerk. And the board asked the parties to consider whether there was an alternative to litigation, do some kind of mediation or alternative settlement where they could work this out. Mr. Killian is out of the country serving his guard duty service and is unavailable today, but the judge had requested that their attorney be allowed to speak to the board to kind of give us an update on the status of that process before they agreed upon settlement before they proceed to litigation. And so I'd like to dial Mr. Kammerer in to allow him to address the board. I've spoken not with Mr. Kammerer, but with the prosecuting attorney, but also I've spoken with briefly Judge Ekstrom and with Mr. Killian. I think there's probably some room to consider negotiating and try to preclude litigation, but they want to have some of this conversation directly with the board. I think that's probably a good idea so that you can be informed. We won't make a decision today. Mr. Killian will be back next week with respect to whether we want to provide any additional funding for attorneys or litigation costs. But I wanted to allow them an opportunity to kind of give an update on where they are towards avoiding litigation.
Any objection from the board?
Need all the information we can get.
So, Mr. Killian, just a very slight technical adjustment, is actually on Navy Reserve duty overseas. Guard is kind of a state thing. Guard guys get deployed too. I don't want to take that away from them, but yeah, just a minor detail. There has been additional conflict between those offices this week. Is that part of this discussion as well, do you know? I guess we'll find out. Let's bring up Mr. Camera, please.
The call cannot be. Please confirm.
Take care of it.
Get one first.
Clerk.
Good morning, Molly, an attorney.
Yes, this is Keith Johnson with Franklin County and the Board of Commissioners calling for Mr. Kammerer.
One.
Thank you.
This is Dale.
Dale, good morning. This is Keith Johnson from the Franklin County. I'm with the Board of Commissioners in a public meeting this morning, asking you to brief the board on the update of where we are on potentially avoiding litigation of the matter between the judges and the clerk.
Okay.
Just to let you know that you're on speakerphone in a public meeting with the full Board of Commissioners here.
All right, thank you. And yes, I'm speaking for the judges in this matter, on the same basis as the last time 2 weeks ago, because of their need to avoid appearing to persuade in a public meeting, a public setting, the outcome of litigation. And once again, the judges are committed to implementation of the Odyssey system for electronic storage and use of court records. But the legal issue remains, and it concerns who is entitled to decide when the incremental or total implementation of the Odyssey system can occur. That is not a factual issue that can be negotiated or mediated. It's a legal issue that, from the judge's perspective, either the clerk must concede or a court must decide. That's why we brought this lawsuit, so we could get a court decision, because there's no indication that the clerk will concede that the court is legally entitled to control the records it utilizes and in some instances creates to administer justice through the Superior Court. In the past couple of weeks since we last talked, I've talked to the judges about the mediation suggestion and about technology solutions to current issues related to the Odyssey system. Technology may provide some solutions that need to be incorporated into the use of the Odyssey system. But first, there has to be collaboration, and someone needs to decide what is necessary. And collaboration in this instance is more than the clerk and the Superior Court negotiating. It has to include the Bar Association, the criminal defense organizations, volunteer legal aid organizations, and other interest groups that use the court system. And the product of that needs to be something that assures due process and is otherwise functional. But in a mediation setting, everyone's equal. Whereas when a legal issue is central to a debate, the law controls, and it determines who is in charge of the outcome of the debate. And legal rights, legal questions are decided in court actions unless the parties all stipulate. and that's another word for the clerk conceding that it is the court that controls its records. In the last 2 weeks that have passed, there have been 2 instances where the clerk's electronic processes failed. One involved the failure to make timely deliver of an order of the court relating to the incarceration of an individual. The other involved a failure of a deputy clerk to attend an on-the-record hearing because the clerk had decided that the type of hearing involved was not supposed to be in the Odyssey system. And that was a decision made by the clerk without consulting the judges. And the result of that was it caused delay and confusion in the courtroom, and it adversely affected the rights of the litigants who were before the court. That's the kind of thing that needs to be avoided and can be avoided when the court is in control of the decision-making that designs the system and provides for its utilization, because the court is obligated to assure due process. Both of the situations that I've described were ones where the clerk had unilaterally decided how the electronic system would be configured and used, and both proved to be inadequate. In cases where the electronic system fails in the circumstance of a person's incarceration or release from jail, constitutional due process rights are affected. If you hold a person in jail 1 day longer than he is supposed to be there, you violate his constitutional rights. And that's something that has to be avoided, in part because of what I'm very familiar with. We don't want the county to be liable for the deprivation of someone's constitutional rights. So these things have to be done correctly, and this necessitates court control over the design and implementation of the system, because the court is the one that has to assure due process rights are protected. And so we're back, I think, to square one in terms of our request, and that is that the board authorize the funding that's necessary, subject to the limitations I discussed earlier, so we can get a court decision. Alternatively, the clerk could concede and stipulate to the court's control over the development and implementation of the Odyssey system. I don't think that's going to happen, so I think we're back to the judicial process for a resolution of the issue. So I'd be happy to answer questions, and thank you for your time.
Any questions? So, Mr. Kammerer, this is Commissioner Peck. The state AG was consulted earlier in this process and asked if they would fund the judge's legal action on the premise that the Superior Court is functioning as an agent of the state. And they declined that opportunity, they said, for administrative reasons and how the funds would be administered. I'm wondering if you have an opinion as to whether or not another avenue for resolution might be to make a formal request of the state AG's office for an AG opinion as to the merits of the judge's position that they have the legal authority to establish and enforce court rules and require the clerk to follow them. Would an AGO, an AG opinion, be of any value in getting to that point short of litigation?
Well, there is an Attorney General opinion that addresses this issue. It's one we cited in our motion for the order to show cause and the writ of mandamus. It doesn't address this exact question, but it does address the question of the court's authority over the records of the clerk. Here's the question that they were asked in that case. Do the judges of the Superior Court of a county have the authority to adopt a local rule that requires the clerk of the Superior Court to have all original pleadings and documents that are filed with the clerk's office pertaining to an active case physically filed within 3 court days of physical receipt in the clerk's office? So, and of course this was long before the Odyssey systems. It was in 2001. And essentially the court answered those questions in the affirmative. And so it relates to the court rule that we have at issue here in this case, which the court adopted an order or a rule in January directing that the clerk provide paper files to the judges pending the full adoption of the Odyssey system with the judge's approval. So we think that existing Attorney General opinion is strongly in support of their position that they can issue this kind of a rule, and once it is issued, that the clerk is obligated to follow it. You can always be more specific, I think, in making an Attorney General opinion request. I don't have any idea of how that would be received there or how long it would take to get the opinion.
Is it your view that physical record means a tangible, probably paper document as opposed to having it filed 3 days electronically?
Yes. I mean, our issue doesn't concern the 3-day filing.
I understand. I'm just going to the issue of physical versus electronic record.
Yes. The judges want to have the paper type of records that they have traditionally used available to them.
Right.
The Odyssey system is not fully up and running to provide those records electronically everywhere they need to have them.
Well, I meant to ask, your interpretation of the AGO's opinion is that when it speaks to physical records, you take that to mean physical paper documents, and you've already acknowledged that it was probably issued long before Odyssey or electronic records, so I think that's probably a reasonable assumption, but you think that's still applicable to the same degree, even with the electronic records we have today?
Yes, I do.
Okay, all right. I don't have any other questions. Any others from commissioners? Okay. Thank you, Mr. Kammerer. We appreciate your time.
Okay.
All right, thank you. We'll be revisiting this issue next week when Mr. Killian is back in the office.
Okay, thank you.
Thanks, Dale.
Okay, other office administrative business?
I'm requesting an executive session under RCW 42.30.110, paragraph 1, subparagraph I, to discuss with counsel legal matters relating to litigation or potential litigation, up to 25 minutes. Would ask that Prosecutor Sant and Jan Johnson, myself, clerk of the board be allowed to participate.
Are you anticipating any action following that?
No.
Okay. Let's make an opportunity for another public comment period. Anybody wishing to meet with the board? Okay. Then we'll move past that to executive session, which you've already made requests for. We'll go into executive session at approximately 1:02, and that'll be for up to 25 minutes as requested.
It's 10:02.
Excuse me, 10:02. Thank you. Okay, it is 10:27 approximately. We've just concluded our executive session under, well, it was read previously, so I won't try to do it from memory. And that was 25 minutes. Next item on the agenda is adjournment, but I'd like to take a moment if there's any issues that any commissioner wishes to speak to. Certainly now would be the time. Any updates, anything?
I'd just like to mention, I was at ECA on April 10th. Had quite an interesting time there again with all the issues that we discussed, a lot of speakers, but I also visited with Newhouse's office at the time when the committee passed the HR 3144. And I talked with their assistant, got caught up with some issues, Sean O'Brien. Also visited the the USDA with their urban growth for small communities. Met with them, and then also more recent was the Washington State local meeting with Columbia River Treaty. That was called the Lake Roosevelt Forum. There's a certain invitation for some groups for Geo Small, who is the negotiator for this. At this Lake Roosevelt Forum, it was surprising to see the number of tribes there that support the salmon, safety of salmon, the dams, things like this. The Canadian side, their discussion is that they want more consistent because they have a lot of reservoirs that dry up and have mud flaps through it. The discussion there, of course, we stood with our side, what our issues were, flood control, other things.
They want more consistency in what?
They want on the flow of water than the Canada does. In other words, they got a Libby Dam back there. This dam holds all this water. They want more, but because of us, they say they can't let it go. And because of our agreement with how much we take or whatever, and I don't find that correct because they've got lots of water. I think they could spill more over. I think we have down draw with Lake Roosevelt also at that time. So that's what I mentioned, is we need to be consistent all over. And flooding is our big issue. But the big thing we discussed is not to have to pay the money to them for power, which of course will be determined in the agreement that is actually working at this time, as they're discussing now and debating now at this time. So that's what I had done. Let's see, anything else? No, I don't see anything else that's worth speaking of at this time.
Mr. Cook, anything?
Nothing that I've been in town the last week or so.
Yep. Okay. Had a outbrief with the state auditor, 10 days ago, something like that. And one of the items that came out of that was a concern about specific compliance with the RCWs on indigent veterans programs. Back in about 05 or 06, before I got here, it appears that the American Legion was established sort of as a dual entity to be our advisory board, but also to handle the administration of handing out those funds. And so there's certainly at least the appearance that we don't have a Veterans Advisory Board, an independent body. So I went ahead and right after that meeting, same day, put a short news release out saying that we're creating one and we're looking for volunteers. Had it put on the county's website. I've already been approached by 6 or 8, not only qualified, but I would say exceedingly well qualified veterans. We're talking community leaders, pastors, attorneys, and some of them with some very impressive military service credentials, combat time, Green Berets, forward air controllers in combat zones. I mean, these are people who have been there and seen it for real, and so I think their perspectives would be especially valuable. So unless there's objection from the board, I'm going to continue to chase this. The plan is to, with the board's approval at various points, obviously, to impanel an advisory board. I note that in the RCW on Veterans Affairs, which is moderately long, I don't find and haven't found, nor has anyone else been able to show me anything that says that this advisory board has to be solely restricted to Franklin County veterans. And there are some really good ones in Benton County who are interested in serving. And so I'll be bringing all those applications to the board for your review, consideration, and hopefully your approval. And then in parallel with that, I'll be working on the county's policies for this program to make sure that they're also up to speed. So just to be clear, I'm volunteering to do the legwork. The board will make the decision on who gets appointed and what policies get approved.
Really interesting that it is not required to be a Franklin County resident. Veteran.
I can't find that anywhere in the RCW. It may have been an oversight when it was written, but it does specifically say that it wants a majority of the advisory board members to be members of or representatives of nationally recognized veterans organizations. We know a few of those, the VFW and the American Legion and those kinds. I'm a VFW member. But there are numerous other federally recognized veterans groups too, and some of these people that have applied are from those, which I think is excellent because they're ones I didn't even know existed. So anyway, I'll keep you posted on what's going there, but because it was brought up in the audit report, I wanted to make sure that we jumped right on it and got it taken care of. So.
Yeah. So does this veteran board only basically the vouchers, the discussion on vouchers, or is there more to it?
This is for the administration of the indigent veterans funds, which come from a small tax item on the property tax. But the advisory board does not need to be limited to that. And in fact, my proposal is going to be an advisory board that handles those statutory obligations of the Indigent Veterans Fund, but also has a much broader application, which is to advocate for veterans in Franklin County, recommend programs, recommend policies. Obviously, it all comes back to the board for approval and a decision as to whether or not we want to do it. But I think the board should have a lot more value than simply, recommending approval of indigent veteran vouchers. So, but again, I'll keep you posted, and that's everything is subject to board approval. So you'll be in the loop whether you want all those details.
Revenue is generated like 1/4 or 1%.
It's a very small number, and currently
the lowest you can go, and they can go up to 3.5 or something. I forget what the
right
top number is, but
that's part of what I was alluding to with this advisory board is if they can come to us and say we really need this and this is the plan and this is what we think it costs, then I think there's an opportunity for a board to make an informed decision as to whether we want to leave things as they are, or maybe we do want to bump that up a skosh to fund something. But ultimately that comes back to the board. But we don't know what we don't know, and having a high quality group of veterans out there advising us. Of this group that I mentioned, by the way, the one who is a local pastor also is a published author and is working on his PhD. Another one is a local practicing attorney. It was just an interesting, very accomplished group of individuals. I was quite pleased. A lot of other things going on, but that was the one that I really wanted to speak to today. If you would be thinking about next week, because it looks like we're going to be looking at a decision on this issue with the judges and Mr. Killian, and whether or not we're going to be willing to fund both sides of the lawsuit. That's it for today. Okay, anything else?
I have nothing else.
Okay, we're adjourned.